Key point review. Title is ownership, or the right to ownership, of land and evidence of that ownership. Voluntary alienation is the voluntary transfer of title to real estate by gift or sale, using some form of deed. Grantor must be of legal age and legally competent to execute a deed. A deed executed by a minor is voidable. Mental impairment at time of signing deed makes the deed voidable. If the grantor has been declared incompetent by a judge, the deed is void. All names the grantor has used should be provided. Grantee must be identifiable with sufficient certainty. Consideration of some form must be stated. Essential elements of a valid deed include the following. Granting clause must be used. Legal description of the property conveyed is essential. Exceptions or reservations of any relevance must be included. Signature of the grantor must be acknowledged by a notary public or other official authorized by the state in which the property is located. Delivery of the deed and acceptance by the grantee are necessary. Non-essential elements of a deed include the following. 1. Does not need to be dated. 2. Does not need to show exact amount of consideration. 3. Does not need to be acknowledged. 4. Does not have to be recorded, but highly recommended. 5. Does not have to be sealed. Types of deeds include the following. 1. General warranty deed provides the greatest protection to the grantee, and includes I. Covenant of cession, warrants the grantor has the right to convey title. I. Covenant against encumbrances, warrants the property is free from liens or encumbrances, unless expressly stated. AI. Covenant of quiet enjoyment, makes the grantor liable for damages if the grantee's title is found to be inferior. If. Covenant of further assurance, the grantor's promise to obtain any other document necessary to convey good title, and the covenant of warranty forever, the grantor's promise to compensate the grantee if title fails at any future time. 2. Special warranty deed includes the warranties that the grantor received title, and that the property was not encumbered during the time the grantor held title, except as otherwise noted. 3. Bargain and sale deed implies that the grantor holds title and possession of the property, and there are no express warranties against encumbrances. 4. Quitclaim deed provides the least protection of any deed, carries no covenants or warranties, and conveys only whatever interest the grantor may have when the deed is delivered. Excise tax is required to be affixed to deeds and conveyances before being recorded, at the tax rate of $1 per $500 of value in North Carolina. Involuntary alienation of title to property is usually by operation of law. Escheat is property taken by state when deceased has no heirs. Eminent domain is property taken by public or government agency. Foreclosure is property taken by creditor for non-payment of debt secured by real property. Adverse possession is property seizure occurring when someone who is not the lawful owner takes possession of property for the length of time specified by state law, and usually in a way that is open, continuous, exclusive, adverse, and notorious. Transfer of title by will occurs when the deceased dies testate. Wills take effect only after death and can be changed by codicil, or revoked while the testator is still alive. Devise is a gift of real property by will to the devicee. Bequest is a gift of personal property to a beneficiary. Legacy is a gift of money. To pass title to property on death, the will must be filed with the court and probated. Wills cannot supersede state laws protecting inheritance rights, or survivorship clause in the titles. Transfer of title under North Carolina Intestate Succession Act occurs when a person dies intestate. Probate proceedings must have an administrator appointed, and laws of the state where the real property is located govern property distribution. Chain of title is a record of property ownership, but it does not include liens and other encumbrances. A gap in the chain or other dispute of ownership creates a cloud on the title. A cloud on title is resolved by action to quiet title. An abstract of title, prepared by an abstractor or an attorney, is a summary report of what the title search reveals. It includes all recorded liens and encumbrances and lists records searched but does not indicate forgeries and interests that are unrecorded or could be discovered by property inspection. A marketable title is one that must not have serious defects, nor rely on doubtful questions of law or fact to prove its validity, not expose the purchaser to litigation or threaten quiet enjoyment of property, and convince a reasonably well-informed and prudent purchaser that the property could be sold or mortgaged at a later time. Proof of ownership may be established by certificate of title, but it will not reveal unrecorded liens or rights of parties in possession. Unrecorded documents that may affect title, such as a tax lien, may not be recorded immediately, yet are still given priority by law and require a search of tax records and other sources. To serve as constructive notice, and with priority over subsequent documents, a written document is needed that affects an estate, right, title, or interest in land, must be drafted and executed, is written according to state law, and is recorded in the public records that are maintained by the designated official, such as the recorder of deeds, county clerk, or city clerk, and held in the county in which the property is located. Public records are typically searched by closing attorneys and title companies that provide title insurance to prospective purchasers based on the findings of the title search. Constructive notice of a document is assumed when due diligence would reveal its existence. Actual notice means that an individual has direct knowledge of documents in the public records and facts revealed by an inspection of the property. North Carolina Marketable Title Act requires chain of title to be traced back only 30 years in most cases. Title insurance, issued as an owner's policy or mortgagee's policy under which the insured is protected from losses arising from defects in title, insures against hidden defects, and identifies exclusions that include readily apparent title defects, zoning, and others. The Connor Act requires recordation of most real estate-related documents to be enforceable against third parties. Excise tax is required to be affixed to deeds and conveyances before being recorded, at the tax rate of $1 per $500 of value in North Carolina.